Our next bill is House File 2400. It's a Representative Frazier bill, and I believe, Representative Frazier, that your motion is that House File 2400 be placed on the general register. I'll give you a minute to get to the table.
That is correct, Madam Chair.
All right, and Representative Frazier, I believe you also have an A2 amendment. Would you like to move the A2 amendment and explain the A2 amendment?
Yes, Madam Chair, thank you. The A2 amendment, it increases the number of days that allowed for a response to the appellate process from 20 days to 45 days, and that was language worked on with the county attorneys associations to make sure that they were okay with this.
Thank you. Any discussion to the A2 amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Motion prevails. The A2 amendment is adopted. Representative Frazier, your bill is before us as amended. Please explain your bill.
Thank you, Madam Chair, committee members, leads, Vice Chair. House File 2400 is a bill that will revise the language governing exception to the 2-year statute of limitations in Minnesota Statute 590.01. However, this bill is not just about legal technicalities. It is about ensuring that individuals who have been wrongfully convicted have a chance at justice. As it stands, our current law makes Minnesota one of the most restrictive jurisdictions in the nation and the most restrictive in the Midwest, when an individual is seeking to bring forth post-conviction claims based on newly discovered evidence. The requirement that this evidence must demonstrate their innocence by a clear and convincing standard is simply unreasonable. Many cases do not lend themselves to this type of proof, and as a result, people with serious claims are kept in prison and out of the court due to a procedural technicality that has nothing to do with the merits of the case. This bill seeks to rectify this by striking the requirement of this high standard. Instead, if an individual has truly new evidence that supports a legal valid claim for relief, they deserve their day in court. This change would bring Minnesota law more in line with other jurisdictions and ensure that individuals with meritorious claims are not unjustly kept out of court. The case of Marvin Haynes serves as a poignant example of why this legislation is so crucial. Marvin was wrongfully convicted and spent nearly 20 years in prison for a crime he did not commit. It was only through the waiver of the statute of limitations by the Hennepin County Attorney's Office that he was able to have his case reconsidered. We cannot rely on such waivers to ensure justice is served. We need a more reasonable standard in place. And I hope we all can support House File 2400 to allow for that more reasonable standard. Let us ensure that individuals like Marvin Haynes have their shot at justice and are not kept out of court due to procedural technicalities. I'll yield to my testifier.
All right. Welcome back to the committee. Andrew Marquardt, please introduce yourself and begin your testimony.
Thank you, Chair Moeller and members of the committee. My name is Andrew Marquardt. I'm a managing attorney at Great North Innocence Project. We represent individuals who've been wrongfully convicted of crimes and work to promote public policies that prevent and help remedy wrongful convictions. And the reason our organization exists is that sometimes the system gets it wrong. Sometimes we put innocent people in prison, and we need to have procedures that allow us to fix those errors when they happen. That's what this bill is about. I'll keep my remarks brief because Representative Frazier summarized it well. But the problem is right now, if you're more than 2 years out, it is almost impossible in most cases to get back into court. Unless you have DNA, something of similarly dispositive, the standard just makes it exceedingly difficult. And in many cases, you just don't have that kind of evidence. And we're just talking about the standard for getting past the statute of limitations here, right? We're not talking about the standard for getting relief. We're talking about getting into court, not about going home. So this would give a more reasonable standard for getting over that procedural hurdle, and then you have a chance to make your case. You might win, you might lose. You got to prove your case, but at least you get a chance. And today, too many people are being denied that chance. People like our client, Marvin Haynes, and there are more people out there like him. So this will create a more reasonable standard. I hope you will support the bill, and I'm happy to answer any questions you may have. Thank you.
Thank you. And we had one member of the public sign up to testify, Hennepin County Attorney Mary Moriarty. Welcome back to the committee. Please introduce yourself and begin your testimony.
Thank you, Chair Moeller and committee members. My name is Mary Moriarty. I'm the Hennepin County Attorney. Thank you for the opportunity to express my heartfelt and wholehearted support for House File 2400. I made the decision not to argue that Marvin Haynes had missed the statutory deadline on his post-conviction petition, which allowed him to get into court and present his case. Without that threshold decision, Mr. Haynes, an innocent man, would still be in prison today. I want to be clear that while I agreed to waive that statute of limitations, he and his team presented compelling evidence that convinced us and the judge that he was innocent. Early in my term, I made the decision to waive the time bar. I didn't really know a whole lot about his case at that point, but I was committed to letting him have his chance in court. The judge granted a hearing. As this was happening, I, for the first time, read the entire file. I remember feeling sick to my stomach as I realized that he was actually innocent and that he had been in prison for over 19 years. We must be open to believing that there can be new evidence in old cases. Police officers retire and feel that they can be honest about what happened, which is what happened in this case. Our understanding of forensic evidence evolves. We become aware of the harmful practices, impacts of practices that were once believed to be effective. I can't adequately describe how it felt to read his case file and the information from the hearing and understand the randomness of Mr. Hayes' ability to get his case heard. That is the feeling that lingers with me today. We should all be extremely concerned that the statutory bar is currently so high that an innocent man needed the discretionary decision of a single county attorney to even get into the court. That is why this bill is so important. Thank you.
Thank you. Any other members of the public who wish to testify on this bill? All right, I'm not seeing anybody. Member discussion to the bill. I just want to say thank you, Representative Frazier. Thank you to the Innocence Project for your continued work on this. It came last year, and I was a little worried it was too broad, and I appreciate that the County Attorneys Association as well spent time working together with the Innocence Project to get this language right, and also appreciative of the fact that the 45-day extension was added onto the bill. I know as someone who practices appeals, when these cases come in, it is quite common to get extensions anyway, because a lot of times they're older cases. The attorneys who handled the initial direct appeal or the prosecution are no longer there. It takes time to go through the file. So I really appreciate all of the good collaborative work that's been done with the stakeholders on this bill. Any other members wishing to speak? Representative Hudson.
Thank you, Madam Chair. Thank you, Representative Frazier. Can you walk me through and articulate how the new evidentiary standard compares to clear and convincing evidence?
All right. All right. Do we want Mr. Marquardt? Would you like to answer the question?
Thank you, Madam Chair, and thank you for the question, Representative Hudson. So the language that is being struck with this bill required that you have new evidence that makes an affirmative showing of innocence by a clear and convincing standard. There's two problems with that. One, it's an affirmative showing of innocence, which is proving a negative, proving that you didn't do something, as opposed to new evidence that in some way undermines the conviction. So that's problematic because in cases where you don't have something like DNA, it's often just impossible to make that sort of proof of a negative. The other part is that the clear and convincing standard is just very high. I mean, that's other than beyond a reasonable doubt, that's the highest standard we have. So that the combination of those two factors really makes our current law an outlier, as Representative Frazier was describing. Most states don't make it this hard just to get over the statute of limitations. So that's kind of the core problem. In terms of the new language, the basic idea is you have to have new evidence, and it has to be truly new evidence, which means it couldn't have been discovered previously through the exercise of due diligence, which is a really meaningful limitation. Many cases get thrown out on that part. But if you have new evidence, and it goes to supporting an otherwise legally cognizable claim, then you get your day in court. So you need to have basically the facts that you would need to make out the elements of a legally recognized claim, and they have to be new facts.
Representative Hudson.
Thank you, Madam Chair, and thank you for that clarification. It's very, very helpful. I'll just say I actually like what you're doing here, and the reason why is because often I hear arguments in the public discourse that we should not be as hard on people who find themselves on the wrong side of the justice system because of the errors that are made sometimes and the number of people who are convicted even though they are in fact innocent. And my argument back to that has always been, well, let's fix that problem. Let's provide a way for people to not be convicted when they're innocent, or in this case, to have it overturned in an expedient fashion. So thank you, Representative Frazier.
Further member discussion? Right, closing comments, Representative Frazier.
Representative Hudson, there will be a quiz next week based on that. No, thank you all for the discussion. I think this is, I know this is a good bill. It's something that needs to happen to rectify some of the issues that systemically we have in place to prevent people from having the opportunity to have the merits heard when they've been unjustly convicted. So please, let's move forward.
Right, Representative Frazier renews the motion that House File 2400 as amended be placed on the general register. All those in favor signify by saying aye. Aye. Opposed? The motion prevails.